What makes all of this interesting is that, according to the Attorney General of Ghana, this case has gone in favor of the country and Ghana has won. But in the eyes of ENI Ghana, they have rather been vindicated with regard to this agreement between the government of Ghana, and ENI. And the question is being raised as to who is right in this particular instance, who has won, because according to the Attorney General, we've saved some 7 billion US dollars that hitherto we're going to pay if this case had been successful. But according to ENI, what they were actually looking for in court is what the court has given to them, and the court is even telling the government of Ghana, to pay the court fees that have been incurred, on behalf of ENI and all of that. Murtala Inusa is still here in the studio with me, and we'll be engaging him on this. Also, we're going to engage someone within the energy space. Nana Amwesi will be joining us, and he'll help us also understand exactly what is happening in this regard. Nana Amwesi is an energy expert, and so it'll be very, very interesting to hear from him. He is the executive director of the Institute of Energy Security, so he'll be joining us on the phone line as well. But Murtala Inusa, let's try and break this down. Okay, first of all, let's help anyone who is listening right now to understand what this whole case is about. Let's start from there.
So this is a matter, if you look at the background that was provided, INI and Vitol contested the action of the Republic of Ghana in this oil exploration activities and all that, and which had Ghana has sought to compel unitization of producing Sankofa oil field in OCTP with an adjacent discovery in WCTPA. So and in fact, the INI and then Vitol were not happy with it, so they took the matter to the International Arbitration Tribunal. And on the 8th of July, the tribunal came out with its final award. And just when the tribunal came out with its final award, we had, in fact, the panel of that particular tribunal were 3 of them. Then we had a statement from the Office of the Attorney General. In fact, this one, it was signed by Godfred Yeboah-Dami, Attorney General and Minister for Justice. And just let me walk you through so that people will understand why this conversation is very relevant for the kind of conversation that we are having now. So the statement, which was tied to say to all press houses, and then they said press release, then it came out with the final award in international arbitration between INI and Vitol versus Government of Ghana and Ghana National Petroleum Corporation. Then it went on, in fact, it is about 11 paragraph.
But let's take a look at the relevant ones.
Absolutely.
Which the Attorney General wants us to emphasize on. So, that went in favor of Ghana.
Yes. So let me even start with the first paragraph.
Yes.
On the 8th of July, the International Arbitration Tribunal, in the action instated by INI Ghana Exploration and Petroleum Limited and Vitol Government of Vitol Upstream Ghana Limited, collectively called claimants against the Government of Ghana and Ghana National Corporation, issued its final award. So, and then it said that the tribunal dismissed the claimant's request, that the tribunal declared that Ghana breached the petroleum agreement by refusing to withdraw or prevent reliance by third parties on the unitization directive. Then he went on to say that the tribunal also dismissed the claimant's request that Ghana notify the High Court, Court of Appeal, Supreme Court of Ghana, that the unitization directive were issued in breach of the petroleum agreement. Then he went on. Let me just move to the 5th paragraph. Then he says, look, the tribunal, however, affirmed Ghana's rights or authority to unitize oil field to achieve effective exploration.
Efficient exploration.
Efficient exploration of the deposits. This paves the way to unitize the Afina and Sankofa field, or indeed any other oil fields, in accordance with the procedure prescribed by the laws of Ghana and the relevant petroleum. And Lantam, listen to this one. It said, the tribunal denied the claimant all claims to monetary damages or compensation. The claimant claimed 7 billion United States dollars. This was subsequently reviewed to $915 million plus interest by the end of the proceedings. This was dismissed in its entirety. So that is in effect what the Attorney General's statement. And in fact, he went ahead to said the Attorney General has observed series of false publications by elements who were not party to the proceedings. The award in respect of which was released within the premise of the confidentiality agreement executed by the parties, but who are on a vile and misguided mission to cast aspersions on the government of Ghana's recent impeccable record in international arbitration proceedings since assuming office. They said the public is hereby entreated to disregard such false publications about the INI Vitol Award, which within the circumstances represent a major victory for the Republic of Ghana. And the Attorney General remains resolute in defending the neutral resources or the natural resources of the state, and will continue to vigorously contest all international and local arbitration claims and actions against the Republic of Ghana calculated at imposing unnecessary judgment debts of the country, and signed by Godfred Yeboah-Dame. So this is the statement that was issued by the Attorney General immediately the award came out. And
so this is a positive projection.
Absolutely.
A positive projection from Attorney General. So there was supposed to be unitization, right?
Absolutely.
ENI and Vitol contested the actions of the Republic of Ghana, which had sought to compel a unitization
Absolutely.
of the production or the producing Sankofa oil field in OCTP with an adjacent discovery in the WCTP2 and the Anifa discovery, which has not been appraised or tested. So this was the issue that ENI and Vitol contested together with the Republic of Ghana.
Exactly.
And when they went to courts, they were seeking damages of about $7 billion US dollars. Later on, that figure was revised, according to the Attorney General's statement, to $915 million US dollars with interest. But the Attorney General is telling us that the tribunal that ENI and Vitol went to dismissed in entirety the claims that were being made by ENI, and the Attorney General believes that this is very, very positive for the country, and the country has been saved some 7 billion United States dollars. Of course, if the judgment had gone in favor of ENI, according to the Attorney General, it means that Ghana would have had to fork out some 7 billion United States dollars because of this particular issue. The tribunal, one other thing which is in the Attorney General statement here is that is noteworthy, is that regarding allocation of fees and costs, the tribunal held that all the parties would be required to pay their own legal fees and costs. So the tribunal has ordered Ghana to pay 189,000 euros to the Stockholm Chamber of Commerce on behalf of the SCC's charges, right? On behalf of the Stockholm Chamber of Commerce's charges. So this is a charge that has been put on the country, by the tribunal, right? And ENI themselves have also issued a statement in the aftermath of all of this. And ENI is saying that ENI Ghana Exploration and Production and Vitol Upstream Ghana have received a positive decision from an international arbitral tribunal.
So who is the winner here?
Regarding their unitization dispute with the Republic of Ghana, ruling in favor of their long-standing opposition to the Ministry of Energy's unitization directives.
Yes.
And all of these unitization issues, I mean, if it's something that we do not understand, we'll get a proper understanding of it from our energy experts when he joins us on the line. They go on further to say that the International Arbitration Tribunal has concluded that the unitization directives were wrong and unlawful, and that the Republic of Ghana's actions breached Ghanaian law and the terms of the OCTP Petroleum Agreement. So according to the tribunal, and this is ENI's account, according to the tribunal, Ghana breached, the actions that Ghana took with regard to this particular agreement on the unitization, Ghana breached its own laws, our own laws that we have put in place with regard to this particular kind of thing. We breached our own laws and also the terms of the OCTP petroleum agreement. Now, they go on further to say that the ruling is also without prejudice to ENI and Vitol's right to claim damages if the wrongful directives are henceforth enforced. So ENI Ghana and Vitol remain committed to the Ghana and the OCTP project, a flagship project backed by the World Bank, which supplies Ghana a significant share of its gas for domestic use. ENI and Vitol have consistently maintained their willingness to assess the case for and against unitization if the processes were conducted fairly, transparently, and in line with best international practices and Ghanaian law. However, they oppose the processes adopted by the Republic of Ghana because of its failure to meet the applicable legal and industry requirements. ENI and Vitol value the relationship with the Republic of Ghana and hope that this award will help bring this dispute to a close, thereby allowing all parties to focus on the continued development of Ghana's oil and gas sector. Absolutely. So this is what ENI is also saying.
So now we've heard from the Attorney General's office, and now we've heard from the ENI itself. And so what exactly is the final award also saying? Mm-hmm. And Lantam, the panel, there were three. Let me just give you their names.
The panel on the arbitration.
Yes, that dealt with this very issue. Three.
Yes.
The president of the panel was Professor Gabriela Kaufman-Collier. He's the president. Then another arbiter is Miss Judith Gill, KC. Then the last of is Professor Dr. Mohammed Abdel Wahab. He's also an arbiter. And this is what they say. So let's now put to you what their final decision on this whole arbitration or this whole matter that went to arbitration, for which reason we are seeing a statement from the Attorney General.
So this is the arbitral award.
Absolutely. And if you look at it, Lantam, it is 144-page final award from that tribunal. And this is this is the conclusion that it said. It said, for the foregoing reason, the tribunal, 1, declares that the Republic of Ghana breached the petroleum agreement by issuing the unitization directive in the circumstances in which they were issued. That is the first point that they make. That is their final conclusion. Number 2, the tribunal declares that each party shall bear its own cost. The third point, the tribunal orders the Republic of Ghana to pay any Ghana Exploration and Production Limited and to Vitol Upstream Ghana Limited 189,900 euros for the cost of tribunal and SCC. Are you listening? Then it went on to say the tribunal dismisses all other requests for relief. So some of the relief that were being sought, those who were granted, is what the tribunal is saying. And then the others that were rejected, the tribunal also made the point. It said, a party may challenge this award pursuant to section 34, beg your pardon, of the Swedish Arbitration Act, Swedish Code of Statute SFS 1999.116 update. So it's just making references to some of the things that you can look. But in effect, what the tribunal is saying is that Ghana has breached the petroleum agreements, and for that matter, Ghana has been ordered to pay INI and then Vitol Upstream the sum of 189,900 euros for the cost of the tribunal. Yes. So that is what we have in hand. Really. So now you have the opportunity to listen to what the Attorney General has said, what INI has said, and now the decision from the panel.
This is interesting. At the end of the day, it will look as though the amount in damages of 7 billion that ENI was looking for was dismissed. But in essence, it seems as though the judgment is going in favor of ENI, if what ENI is saying is anything to go by.
Absolutely. Yes, that's how it seems like. So everybody is claiming, because you look at the Attorney General's request, they are saying that after the INI went to the arbitration, there was a counter claims that were filed by the Attorney General, and they analyzed that and was able to make a point, was able to make a determination as to what exactly the issues are. And based on the analysis that were made, they also were of the view that some of the reliefs that were sought should be granted, and others that were also sought should be refused. So that is how come you see the panel saying that, look, whatever has been said, they have looked at it, they have examined it, and they provide so many analysis. And I tell you about the fact that it is 145-page document in which they have analyzed all these and make sure that they have subjected to the various laws and all that, and came up with this very conclusion, and very extensive one. If you look at the document, very bulky one and all that. And so they made a lot of presentation. They made a lot of, for instance, one of the things that the claimants was seeking in relation to this very one was one. The claimant contend that the unitization that Ghana imposed on them violated fundamental, procedural, and substantive protection under Ghanaian law, the principles of fairness, transparency, and reasonableness, as well as the petroleum agreement. The respondent opposed these claims and contend that the possibility of unitization was built into the applicable legal and contractual framework, and that Ghana carried out the process in full compliance with such regime before setting out its analysis. The tribunal summarizes the parties' position. So after this is the contention of both parties here, and then the panel went in to look at what kind of presentation have each of the parties been making. And for instance, if you look at what the claimant, and the claimant here represents INI and then Vitol, and what they said was that the claimant contend that the unitization imposed by Ghana, okay, I have stated that earlier in the preamble. So the claimant also admit that Section 34 of the Petroleum Acts and the Regulations 50 of the Petroleum Regulations offered the Ministry of Energy discretion to impose unitization. However, they claim that such discretion is subject to the principles of good governance, including transparency and accountability under Section 3 of the Petroleum Act, as well as Articles 23 and 296 of the Ghanaian Constitution, which guarantees fairness and reasonableness.
Right. Let's stay on this a while longer. I've been joined on the phone line by Nana Amosi the Seventh. He's executive director of the Institute of Energy Security, and we'll have a conversation with him on this. Nana, good morning. Welcome to the Morning Star.
Good morning, Latham. Good morning to your listeners.
Thank you very much for your time. We are discussing this issue between ENI, Vitol, the government of Ghana, GMPC, and the Attorney General saying that this is a decision which is in favor of Ghana, ENI saying that it is a decision which is actually in favor of them, with regard to unitization of some oil fields. First of all, help us understand what this unitization is all about, and then let's try and get into the other issues and break it down for our listeners.
Well, thanks for having me this morning. Unitization is a practice in the petroleum industry. Globally, it is practice. It happens when two separate wells seem to have connection with each other. Mostly people will be looking for some dynamic communication, and which refers to the interaction or connectivity between different parts of a reservoir. And so it means that, let's say, a pressure drop in one reservoir may reflect in another reservoir as a pressure rise, for instance. And so we could say that the two wells may be separate, but then they communicate with each other, they interact, and they connect in one way or the other. In that way, you will want to put the two wells or reservoirs together as one and exploit the hydrocarbon So instead of having two separate contractors drilling with two separate assets, let's say FPSO or rigs, you want to employ just one FPSO and drill the oil from the two reservoirs. So you are unitizing it. It's done in the petroleum industry. It enhances efficiency. It enhances production. It reduces cost because you are handling two things as if they are the same. And so the owners of these reservoirs, in let's say A and B, may share in the cost and the profit proportionally and based on their various contribution of oil in place or gas in place. So that's what is done. Most of the time it comes voluntarily because the two people understand that, look, if we choose to exploit our hydrocarbons separately and independently, we'll be incurring more costs. Let's put it together. It's a saving for us. We will make savings on our production, on the assets that we may have to utilize, the insurance we have to pay, and all that. And the regulation cost and all that will be reduced for us. So it enhances our chance to make more money as two separate owners. So this is about unitization, and it's something that's practiced in the oil industry.
Right. And so, with the case of ENI and Vitol Ghana, and of course the government of Ghana and the GNPC, from where you sit, breaking it down for us, what was the issue?
Okay, so the ENI Vitol on one side have their own wealth, and it seems to be adjacent to another block owned by Springfield Oil, and their reservoir, or what they call it, Athena. And what happened is that when Springfield announced their oil find, according to them, their data tells them that their oil straddles that of ENI Vitol, and so they spoke to government. The government GMPC also went to make further assessment and did find, according to them, that yes, the seismic data suggests that there's a connection between the two wells, and so the two parties have to exploit the two separate wells as if they are one, and so they might have to unitize. But then here now the talk is that, look, you have not done enough appraisal on your well. The oil in place, the quantum is not even known. Our data we have, if we even have to take yours as well along, doesn't suggest that there's dynamic communication between the two wells. Government, GMP says that, look, that's in our well, we don't need to do further appraisal. The seismic data suggests that the two wells are almost the same. Same features, same and connection. So go ahead and unitize. And so the former Energy Minister, Amewu, did issue the directive some years ago. I think it was more than 3 years now. And then and I have to say, no, we don't agree. If you say it's in place, we also suggest that you do further appraisal on the final well. Now, when GMPC issued the directive, it is said that when you put the two wells together, the quantum of oil in place as a FINA is more than what you have in your current or your existing system. So, in terms of allocation, Afina will have 55% of that. ENI says no. Look, this is not how it works. Remember, we are guided by laws and regulations. So let's go back to Article 26, Clause 6 of our petroleum agreement. And that one talks about stabilization and also negotiation. And so let's sit down and let's talk about it. What is stabilization? That is basically it aims to protect both parties, both government and the contractor, from unilateral changes to the agreement. While the negotiation clause provides flexibility to modify the agreement in response to significant changes in circumstances. Yes, so I, as ENI, I went to borrow money. I was funded. My guarantees were also supported by other organizations, and they did it based on the understanding that this is my oil in place, this is my volume that I will drill, based on price projections. This is the projected revenue stream, on which basis they gave me the funding so that I could be able to pay them. But if you now come and say I am not entitled to all my oil, then it comes to disrupt my revenue stream. Remember, I have shareholders, and I may be on the exchange, and so my shareholders will have to now vary their decision, knowing that I am losing a sizable chunk of my oil in place. So it comes to destabilize me. So let's go by the stabilization clause, so that we say by what we started with. Okay, if we have to negotiate, what's the way forward? We are saying that let's have a better and a deeper appraisal of the African world. Government says that, look, our data suggests it's the same, and so we are enforcing it. That is what compelled ENI and Vitol to now go to the international arbitration tribunal for justice. Should I put in that word? Then government will also have to respond as a respondent, and government also went to court claiming that they are taking the right position, and the court must affirm the utilization directive for them, while ENI also have been told, as you have read through your listeners, made various claims as well. So that's what happened.
So from where you sit, looking at why you've just told us that Vitol and VNI went to court, and of course the government of Ghana also having to respond in the court, and the judgments that were given. Of course, we know that BNI were looking for some damages, at about 7 billion or so. They didn't get that. But when you look at the crux of the issue, reason which ENI and Vitol went to court, were they vindicated? And when you look at government's position also and how the government handled the agreement and the ruling, who was vindicated here?
It is not so clear for us to tell. You see, we see the ruling as more Solomonic in kind, taking to take a compromise position and taking to be fair to both parties. Ghana go back and re-engage. What the court was clear is that your directive didn't follow procedure. Okay, that is one. But then go back and re-engage Vitol on this matter. Whichever cost both of you incurred, absorb it yourself. That is simple. Meanwhile, we understand that this case was finished almost a year ago. Both parties were asked to submit their technical data supporting their arguments. And so we'll have thought that the tribunal will have brought in technical experts to look at the data and make a conclusive judgment on it and pass a conclusive statement on that. Look, from the data that we have, Springfield or Ghana is not justified to have any utilization. From the data that we have, unitization, the cost for unitization. However, so. Or let's determine the oil in place properly by an independent party. For us, that is GMPC and Ghana on one part, against CNI Vitol on the other side. To this point, an independent assessment is important to determine what the case must be and should be. But the court wasn't so clear. Just that now is walking away, understanding that Ghana couldn't enforce its position. So what's the way forward? Do I continue to proceed exploiting my hydrocarbon without any further disturbance, or I still need to go and engage government on this. The court could have been clearer in a judgment. I think there's a compromise here. But for me, I can't say who won and who lost. It seems to be a compromise judgment that we find.
But in all of this, in all of this, it seems that the court says that Ghana breached certain provisions, of its own laws with regard to agreements like this, and Ghana is notorious for doing things like this. What does that even mean?
It means that we didn't follow procedure and we don't follow our own laws and regulations. It hurts your credibility as a country and threatens further investment in your domain. The oil sector is a very small community. All the players communicate with each other. Today, information is democratized. It's not held by only one person. And so people now understand what's happening. And they are asking, do we have policy certainty in Ghana? Do we have regulatory certainty in Ghana? Or it could be changed at any time. In that way, you are not so sure how your investment will fare in the next few days, the next few years. So it's a dent on our reputation, our credibility, and it is already telling on us. We did warn about 2 years ago when the thing came out. We said we don't have any problem with unitization, but the process and the directive issued by government must be handled well. Other than that, it may hurt investment in our upstream oil sector.
And has it already done that? Has it already hurt any investments in our upstream sector? I mean, we remember that there are some players, within the oil space who have decided to leave Ghana. Is it because of some of these things?
I could speak to ENI and Vitol. They had adjacent wells that they wanted to, drill deeper and produce oil from same. But because of these issues, they have to abandon that idea. And quickly they went to La Côte d'Ivoire. In a space of 22 months after announcing an oil find there, they started production. Today, ENI is virtually out of Ghana. They only launched from La Côte d'Ivoire to offshore Ghana to look at their field there. But then it means that it's come to hurt our oil production and our oil volumes in one way or the other. I can't tell whether it's the same reason for which ExxonMobil left, but then Vitol, ENI, as we get it from them, they have to abandon further, work on their new wells because they find the environment not favorable for them.
What lessons should we be learning, from this as a country? And looking at the posturing seemingly that has been adopted by the government of Ghana through the Attorney General in the statement that was issued, painting a positive picture or a positive outcome of this arbitration. Is that the posturing we should be adopting? And what lessons should we be learning from all of this?
You can't blame the Attorney General. He has to defend his position and route that he took. But I think that we must hear from the Energy Minister on this ruling. And it's important that as a sector minister, he speaks to it. And there should be any assurance that we must take serious or any other position that we must take serious. I think it should come from the Energy Minister. He has the technical and the commercial data. He has the regulation in hand. He engages the parties on a daily basis as the policy formulator and executor. So let's hear from the Energy Minister, Honorable Matthew Opoku-Prempeh, on this. That will give us some more clarity on government position on this matter.
And moving forward, the necessary steps to be taken to make sure that we are not deterring, or should I say, scaring off investors who we need to invest in our country in the oil sector?
Well, it is important that we 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 ensure that any future unitization directive comply with applicable regulations um, to prevent similar disputes or challenge. Then we also expect that both parties will engage in dialogue, uh, so as to make sure that none of them is hurt in the process. Because, as a matter of fact, it is not Ghana that is losing. So it's not only Ghana that is losing this matter. ENI is also losing because this directive came to disrupt the operation, and so it's important that they all engage amicably and explore mutually beneficial arrangements. But it's very important at this point for Ghana to review its legal strategy and regulatory framework to strengthen its position in future disputes. So we maintain some credibility to enhance Ghana's oil exploration and production image.
Very well, Nana Mwesi. I'm grateful that you've spoken to us this morning here on Star FM.
Thanks for having me. Good morning once again.
Good morning to you. Nana Amwesi the seventh is Executive Director for the Institute of Energy Security, helping us break down this whole debacle between the government of Ghana, GMPC, ENI, and Vitol with regard to unitization within the oil space. And there are lessons to be learned from this. At the end of the day, what we should be doing as a country is making sure that we are positioning ourselves well enough to be able to take full advantage of the oil that we have, to attract the right investment into the sector and to benefit from it for the benefit of every single Ghanaian. It's 8:34 a.m. Of course, you're still listening to Starr 103.5 FM. This is the Morning Star. It's also live on Empire 102.7 FM in Takrade. And there's still more to come here on the show. We'll still engage some people within the political space.